Hi, students. Today we're going to focus on the other parts of the memo. We've talked about CREAC, the rule explanation, the rule application. What about the other parts of the memo? So let's start off talking about the heading. The heading's very simple, especially if you've ever written any kind of memo before. You need to address it to whoever assigned it to you. List your name and list the date. Notice here that it's pretty well flushed where it looks nice and neat. You're not just kind of spacing two and so it's all over the place. You need a regarding line as well. That's just the subject of it. It may be the client name, file number, nature of the matter. You want to be as descriptive as possible because this will help other people look at your memo. Now, keep in mind, most memos do not stop and die with the one person you send it to. Memos are passed around all the time, and sometimes they're helpful for other situations. So you want to be descriptive in this section. How do you draft the heading? Think about your reader. Is it more helpful to just say Nadine Jackson claim in your firm? Or is it more helpful to say Nadine Jackson's potential claim for negligent infliction of emotional distress? I would say the second example is much more helpful for your reader. Formatting. Sweat the details. Formatting matters. Your spacing and content of the heading should be tabbed, everything lined up vertically with the other pieces. I already kind of demonstrated that to you earlier where I said the to, from, date. Go ahead and just tab the content over. Make sure your headings of all sections are in bold. Your headings don't need to melt away with your text. They need to stand out. Centering is also a good idea. Your question presented in a brief answer. Traditionally, those are single space. It looks better to be single space. There are some people who stylistically prefer it be double space with the rest of the memo. But I tell you, single spacing at just that section is going to save you a lot of space and actually looks better because those sections tend to be very, very short. Always, always listen to me in this one because this is one of my pet peeves. In fact, I'm going to get my laser pointer out on this one. The document should be left justified or aligned. Never, ever, ever, ever for this class use full justification or full alignment. You don't do that in legal writing, in any form of legal writing, because it will mess up your citations. And spacing is everything when it comes to legal citations and proper attribution to authority. So make sure the document is in fact left justified. Page numbering, bottom of the page after the first. I do not understand why people would put the page numbers at the top left where you would staple the document. That makes no sense to me, but make sure you number your pages. I do have some pet peeves. Here they are. Number one, do not use full justification or alignment. I get so annoyed when a couple of weeks from now, you turn in a document that does just that after I spent a lot of time emphasizing to you, don't do it. Do not use contractions or colloquial language in formal writing. I know contractions are something every day, it's so normal, so easy to do. Don't do it in formal writing. Spell it out. Do not use personal pronouns. I, my, we. And it sets you up to I believe and our client and we think, which is so irrelevant to a legal memo. It's about your analysis of the law, not your opinion. Just stay away from personal pronouns in formal writing. Make sure you remember that commas and periods go inside quotation marks, not outside. Let's talk about drafting the question presented. There are essentially two types when we think about the question presented. The purely legal type is anytime you have a problem where the facts just don't matter, right? The research that you're doing, everything is all based on what is the law. It's just a simple legal question. Here's an example. Is a firearm a deadly weapon? To answer that question, it really doesn't matter what the facts of the case are. You just ask me a pure legal question, and all I need to do is go to the Texas Penal Code and give you an answer. Most frequently, you're going to have to draft predictive questions because you're going to be asked to make a prediction where you apply a rule of law to a set of facts. So your question is going to be structured slightly differently. It's going to be the question plus usually some of the most important facts and sometimes the rule of law. So in my class, I'm not going to give you anything that simple. I'm going to give you predictive documents, so you will need to draft a predictive question presented. So you should always include some of the essential facts for the issue in your question presented. Let me repeat it. In your question presented, always include some of the essential facts. Some people call this issue presented. You know, that's fine. I'm not a huge fan, but that's fine. What are the goals of the question presented? Well, it helps us identify what the focal point of the memo is. What's the claim, crime, defense, or elements? It helps summarize necessary facts related to the dispute, and it should end with a question that identifies the disputed issue. It should not include legal conclusions. Example would be whether the defendant's reckless driving will be considered a form of negligence. Well, calling or characterizing the defendant's driving as reckless is in and of itself a legal conclusion, right? So a better way to phrase that would be whether driving 20 miles over the speed limit would be considered a form of negligence. See the difference? The number of questions in your question presented section should be matching to the number of issues that you're going to address in your discussion, not the number of elements. So if you have a cause of action with 4 elements, only 2 elements are in dispute, then I expect 2, so you have 2 issues, I expect 2 questions presented. If you have multiple questions presented, don't forget to add a plural to question. You should never include minor issues, undisputed, or easily resolvable issues in your question presented. Your question presented really should let the reader know what's the focal point of this document. What are we fighting over? Focus on making sure your issue is narrowly defined. If you state your issue in a very broad manner, almost always, inevitably, a student's paper is going to be very broad and all over the place and unfocused, and we don't want that at all. So if you say, does Smith have a claim for negligent infliction of emotional distress? Well, that's kind of broad. That's like saying, will Smith win their case? Also way too broad. What is the legal issue in dispute and what are you fighting over? That's what needs to be reflected in your question presented. When your issue is framed narrowly, your analysis tends to be more focused. So the narrow legal issue here would be, did Smith have a sensory and contemporaneous observation of the accident to satisfy a negligent infliction of emotional distress claim? And just in case you hadn't noticed, yes, having a sensory and contemporaneous observation is one of the elements in dispute. When you write the question, the format can vary. If it's purely legal, it's just going to be a simple question. We're going to do mainly predictive, so let's focus on that. Your predictive question should be based on the client facts, because your prediction, let's face it, is impacted both by those outcome determinative or essential facts. For example, whether Carrollton can enforce the Watson covenant not to compete when the covenant prohibits Watson from making sales contracts for 3 years and applies to the 3 counties closest to Carrollton's headquarters. So formats for the question presented would be the legal question plus a concise statement of the relevant facts, the legal question, a concise statement in a whether format, the under, does, when format. So can, legal question, when. It's almost just like a formula, right? Did, was, may. Do the Texas rules concerning advertising by our lawyers apply to all of our lawyers and all of our offices when advertising on the internet? Now, that was the specific issue in dispute. Normally, I am not a fan of personal pronouns. The whether format is very traditional. You put whether, legal question, when, and the fact. It's a clause, not a real sentence, but in legal writing, you end it with a period, not a question mark. And it can include a statement of the law or not. Example, whether the Flynn's have a cause of action for either public or private nuisance when Pecos Power had authorization to build the high voltage lines. The high voltage lines obstruct the Flynn's view. The Flynn's no longer use their backyard because of their fear that the EMFs from the high voltage lines may cause cancer, and the Flynn's have been unable to sell their home. whether it is a violation of the Texas disciplinary rules for a partner in our firm to list her qualifications on the firm's website when the partner is not admitted to practice in Texas and does not maintain an office in Texas. And then you have the under, does, when format. Under the Texas Penal Code, a person may be convicted of aggravated robbery if she used or exhibits a deadly weapon during a robbery. Did Jane Dunn use or exhibit a deadly weapon when she brandished a crowbar at the UPS driver and threatened to hit him with it during a robbery? Under the Georgia common law rule that allows covenants not to compete only when the area restrained, the activity is restrained, and the duration of the restraint are reasonable, can a covenant not to compete be enforced when the covenant prohibits the covenantor from making sales contacts for 3 years and applies to the 3 counties closest to the headquarters of the covenant's beneficiary? And then look at the degree of details. Traditionally, question presented is just one readable sentence. But if it ends up looking long, it's better to have 2 clear sentences than 1 confusing one. In terms of how you should refer to your client, you can give the parties' names. I think that's the best practice. But you can also do more general references in terms of their role. Employee and employer, right? Tenant and landlord. Your brief answer. I know some people call this a short answer. I don't know why I don't like short answer, but I will never penalize you for a stylistic choice. If you prefer brief answer or if you prefer short answer over brief answer, that's fine. It should always start with a 1 or 2 word answer. Always a 1 or 2 word answer. Yes, no, probably yes, probably not. And then you're going to give that summary. Citations are disfavored in both the question presented and brief answer. So this is not the time for you to quote a statute or give me rules out of a case. This is actually an opportunity where you get to give that conclusory sentence about what is the basis for your conclusion. It's not a time to evaluate any arguments. It needs to be responsive to the question presented. Frequently, first-time legal writers will have an answer and it doesn't answer the question that they pose. So make sure it's responsive and your question lines up with your answer. It needs to be concise. It should not be longer than a third of a page. And if your question didn't present a legal rule, you can raise it here. Always begin with that 1 word or 2 word short answer and then place a period after the 1 or 2 word short answer if it's yes or no. The answer should reflect your level of certainty. It's okay to say probably if you're truly not certain. It's not okay to say probably not or probably yes if you're just trying to straddle the fence. Yes or no should be included if the outcome is in fact certain, and a lesser degree of certainty, then that would be appropriate. Summarize your legal conclusion. Your brief answer, 1 brief answer per question presented. Make sure the format of your brief answer matches the format of the question presented. Similarly, the order in which you state your question presented in brief answer, if you have multiples, should match the order that you address those issues in your document. Let's talk about the statement of facts. Your statement of facts for legal writing 1 should focus on being objective. You can and should include favorable and unfavorable facts. You don't have a pony in the race. You are just laying out the facts as they are, focusing on the facts that are legally significant. Example, defendant was speeding through the school zone. That's a conclusion. Instead, defendant was traveling 40 miles per hour through the school zone. You can also, in addition to outcome determinative or relevant or essential facts, all meaning the same thing, you can also include background facts because you need to make sure the facts flow and that it makes sense. So anything that you can do to provide context is fine. Procedural information or the posture or the history, if you think it's important to note that the defendant filed a motion for summary judgment or the defendant lost his appeal or any of that procedural information, make sure you put it in the last paragraph, not the beginning. Stick to the facts, no conclusions, arguments, or cases in this section. Include every fact mentioned in the discussion section. Include procedural facts in the last paragraph, be objective. Now, I believe in another video I talked about drafting the thesis paragraph last. You can actually think about drafting your statement of facts last. I say that because even though it's going to feel intuitive to you to just try to attack all this in order, do you really know what the essential facts are yet, right? And you may have a better idea once you've actually engaged in analysis and have a better way of kind of couching the story in the statement of facts. So think about not starting with that, because when you start with it, students tend to put everything, and everything may not be relevant. And don't just repeat the facts I give you verbatim in the assignment. I want you to, summarize it for yourself. The last section in a memo is the conclusion. It has its very own heading. Too often I have students that skip the heading. You need to write in your memo conclusion, and it needs to be bold and centered. It should not be an opportunity for you to try to introduce new arguments or insights or any of that. Instead, you are briefly highlighting your top points. Now, stylistically, people approach the conclusion different ways. Some would like to say, this is my last final argument. I want to hit home the most important points. This section is so important. And I applaud those of you who feel that way. And there's nothing wrong with feeling that way. This is just a stylistic matter. Stylistically, I tend to be of the party that says, for the foregoing reasons, the defendant's going to lose. I make my conclusions very short and sweet. Because for me, as a professor, as a grader, there is absolutely nothing you're going to say in that conclusion that's going to change my mind on your grade. I'm ready to move on to the next paper. So if anything, it's just going to be skimmed over. And I guess even when I was a practicing attorney, I felt the same way. People really weren't reading the conclusion by now, so I just kept it short and sweet. But again, this is a stylistic choice. If you like long conclusions, you will never be penalized from me in this class for a stylistic decision. Keep in mind, objective documents need to be neutral. You shouldn't be argumentative. Instead, you're making a prediction. Now, here's the thing that's going to feel a little strange. Even though I say you're not making an argument in an objective memo, you are still arguing. You are arguing for the validity of your conclusion. Early on in the document, you made a statement. The defendant can or cannot establish a case. The prosecutor will not meet his burden of proof, whatever that conclusion was. Everything else following that conclusion should be you trying to prove it, for you to validate that point. So don't assume that you're not arguing at all. You are. You're arguing that the point or conclusion you made is the correct one. Your prediction should include your reasoning. It's okay to start drafting a document and change your mind. You just need to make sure that you get that uncertainty out before you submit it. But writing is thinking, writing is analysis. So, frequently we'll have students that say, well, I thought this was the answer, but the more I thought about the cases, I think I need to change my mind. That's fine. Just make a decision and a prediction. All right, so that's it, but I do want to share with you one other document. So let me pause this for a moment to pull it up. This document here, I call it the sample memo template. It's already been posted on Stanley. This was originally created by Dean Lisa Yarrow, who's over our bar prep, and I find it very helpful. So notice we already have laid out for you how to do a question presented with the templates, right? It's already here. But the other thing that's really helpful starts on page 4. Nope, I'm wrong. Page 5, the discussion. Here's your checklist. Here's what you need in the discussion. Here's the overview paragraph, CNR, conclusion, rule, elements, non-dispute. So it's really like a checklist. Thesis paragraph, element 1. What about this element? Here's what you need in the thesis paragraph. Rule explanation, topic sentence, followed by the facts, holding, and reasoning, and policy if relevant. A reminder not to mix the rule explanation with the rule application. Then going into your analysis, and then going into, I got lots of tips about the analysis, your second element, and a thesis paragraph regarding that. So depending on your learning style, this can be a really helpful document. So please make sure you take time with this document just to understand before you start writing what you're being asked to do for the memo. So that is it for this particular video. I hope you found it helpful. And as always, if you have any questions, please let me know.